Want to maximize your chances of success in the court. Understanding the nuisance of the court selection can give you a significant advantage. In this video, equipped with the knowledge to choose the court that align perfectly with your case. That is venue shopping. And the venue shopping is a crucial strategy in litigation that allowing the parties to select the most advantageous court for their case. In this video, we will explore the factors influencing venue shopping, including jurisdiction, convenience, and potential biases, providing valuable insight for the paralegal and the legal professional alike. So, are you a new paralegal or a legal enthusiast trying to understand how venue shopping works? And in this video, I'll break down the most powerful yet to understand legal strategy and choosing the right court for your file and to file your case. And you will learn what is venue shopping and why it matters, how to choose right jurisdiction, and the real example of strategic venue selection. Research tip using Canley and Westlaw, and ethical does and don't, and how drafting pleading to support your venue, and also using venue to negotiate and settle. So how I break down? I I have broken down into 5 sections. Number 1, understanding the venue shopping. Number 2, factors influencing venue shopping. And number 3, strategies for successful venue shopping. Number 4, ethical consideration in venue shopping. It is very important. One should know what are the ethical requirements, what they should see. And in last section, number 5, conclusion and navigating the complexities of the venue shopping. So, first, understanding the venue shopping. What is venue shopping? It is when the lawyer or paralegal choose the court like venue. Basically, the court is a venue most favorable to their case. Selection of the court most favorable to their case. And different courts may interpret laws differently or have a reputation for being more sympathetic to certain issues like personal injury or consumer rights. So why legal professionals use it? Because they gain the strategic advantage legally, and some venues may have faster process, higher settlement average, or more favorable juries. And real world examples are a lawyer suing a major corporation might file the case in a jurisdiction known for siding with the consumers even if the company is not based there. So that's a file in the jurisdiction that even the company is not based there. It should benefit in that way. Another real world example and how it impact litigation that can lead to early settlement due to pressure. Another impact is may force defendant to defend the case in unfamiliar legal territory. And another impact is raises ethical question about fairness and manipulation of the legal system. These are the impacts on the litigation: early settlement, and defendant case in unfamiliar legal territory or raises ethical question. So why it matters? So knowing how venue affect a case help you think strategically, not just legally. You will be better prepared to assist in case planning and client advisement. So again, it matter to paralegal that it affect to help think strategically and case planning and client advisement. Factors. Number two, factors influencing venue choice: jurisdiction. Jurisdiction. Personal jurisdiction. This means the court must have the authority over the people or the business involved. For example, if you are suing a company based in Toronto but they have never done business in Alberta, an Alberta court may not have a personal jurisdiction over them. That is how you should understand the personal jurisdiction. And subject matter jurisdiction. The court must be able to hear the type of case, for example, civil, criminal, family, etc. And another example, you cannot file a diverse case in a small claim court. So every court has a certain jurisdiction. A small claim court deal with the matters within their jurisdiction and handle up to $35,000, not more than that. Only the monetary limit is $35,000 for your claim and for any property damage or other thing. You cannot file family matter in small claim court. So that's subject matter jurisdiction. Choice of law. This determines which province or country's laws will apply, especially in cross-border dispute. If a contract was signed in Ontario but the work was done in Quebec, the lawyer must consider which province's laws are more favorable before choosing where to sue. That's a choice of law. Another thing is convenience. Convenience means distant to the court. Filing close to the parties involves save time and efforts. For example, if the both client and the key witness live in Brampton, and filing in Sudbury makes no practical sense and can hurt the case logistically. It doesn't benefit anyone and must be far for the witness, must be far from the parties. It should be close where the people are close by or the parties are close by. And the availability of the witness and evidence. Venue. Again, the venue is a court. Court should be chosen where it is easier to present crucial evidence and have witness attend. For example, workplace harassment case might be filed in the city where the incident occurred because that's where all the witness and the records are located and it's easier to call them and easier to corroborate. And third point is the cost of travel and lodging, especially important for the client with limited resources. For example, choosing a venue that avoid expensive hotel stays or the long travel hours help keep costs down and the client more involved. And potential biases. To understand the potential biases, the judge ruling in similar case. Some judges are known to learn one way on specific type of cases. For example, if a judge in a certain district has ruled against tenant in 9 out of 10 cases, a tenant's lawyer might avoid filing there. That's a thing. If you know before the case, it should be very easier for you. And the local community sentiment. Local community sentiment, the community attitude can affect jury or judge perception. Example, in a small town, the heavily relies on a local factory. Suing that factory for pollution might backfire if the jury sympathize more with the employer than the environment, because that's the only source of uh, money, source of jobs, and so many people are getting employment benefit. Think about it. And prejudice against certain parties. The third part is prejudice against certain parties. Some parties, like large corporations or out of town plaintiffs, may be treated less fairly in certain venues. Example, multinational company may want to move a case from a small rural rural court to the big city, where the jury is less likely to see them as an outsider or villain. So, just again wrapping up all of these things, the venue factor does not just help your supervising lawyer, it makes you a strong legal thinker. Knowing where to file can influence everything from evidence gathering to settlement negotiation. And as a paralegal helping research, the best venues show you are not just following the rules, but you are also playing a legal strategy game. Third section of my breakdown, that strategies for successful venue shopping. So for this thing, you should do the thorough research, examine relevant case law. For example, if a past ruling in a certain jurisdiction consistently favor injured plaintiff, that's a green light for personal injury lawyers to file there. And analyze the judge history and ruling. For example, judge known to deny class actions certification might discourage filing a consumer case in their courtroom. And last part of this thorough research is consider local community perception. Example, filing an environmental lawsuit in a town suffering from pollution could lead to strong jury sympathy and the public support. So, strategic pleading. To understand the strategic pleading, craft pleading to establish jurisdiction. How? It's an example that complaint can be written to highlight events that occurred in a preferred jurisdiction, justifying the court's authority, and frame the case to favor the specific court. I'll give you an example. If one court is known for pro worker ruling, lawyer might emphasize the employment law aspect of a case over contractual ones. So that's how you frame the case, and use persuasive legal argument early on. Just an example, the smart motions and the affidavit can subtly encourage the judge to see why this court is the right place for the case to proceed. And negotiation and settlement. Leverage venue to push for settlement. Example, in filing in a plaintiff friendly court can the pressure the opposing side to settle early rather than risk a tough trial. In another thing in negotiation and settlement, work toward mutually beneficial outcome. How? Example is, once the venue is secure, both sides might agree to resolve the case quickly to avoid cost, delays, and uncertainty. These are the power of negotiation and settlement. And there's a good tip for paralegal. As a paralegal, being part of this venue strategies, doing court research, drafting smart pleading, and tracking settlement trends can make you essential asset to your legal team. Now the fourth part of breakdown, the ethical consideration in venue shopping, avoiding forum shaping. I'll discuss avoiding how to avoid the forum shaping. So first, choose a legitimate venue, not just a friendly one, not friendly one. Example, filing a lawsuit in a court with no real connection to the case, just because it tends to rule favorably, is forum shopping and can be challenged. And second part of the forum shopping, disclose conflict or bias. You have to disclose it before it's gone bad. Example, for example, if a judge has a personal relationship with any one of the parties, that should be disclosed early to avoid unfair influence. And third part, act with integrity throughout the process. How you should do that? Example, don't exaggerate connection to a jurisdiction just to justify venue. Every fact in the pleading should be 100% accurate and supportable. These are the things to avoid forum shopping. Again, I just repeat to remember it. Choose a legitimate value, not just as a friendly, and disclose conflict or bias and act with integrity throughout the process. That's how you avoid the forum shopping. And transparent communication. How should you do that? Explain the reason for the venue choice. I'll give you an example. If you are filing in a certain city because that's where the events occurred, clearly state that in your initial filing. You should do in initial filing that's where the event occurred. In transparent communication, communicate openly with all parties, not only with your parties, all parties involved in the case. Example is that let opposing counsel and the court know your rationale honesty, deceptive tactics can backfire and even lead to sanction. And last part of transparent communication, avoid misleading the court. How should you do? Example is never frame facts in a way to manipulate the venue without basis. This could be seen as a bad faith. Again, in transparent communication, you should look and you should be careful, explain the reason for venue choice, communicate openly with all parties, and avoid misleading the court. That's transparent communication. And respect for the legal system. How you should do that? Uphold fairness and justice for what the courts and the law and the system is made. Fairness and justice. I'll give you an example. Choose a venue where a case can be handled objectively, not just advantageously. And in respect of the legal system, respect the court decision. Whatever the court, a judge made the decision, respect it. For example, if the court decided to transfer the case to a more appropriate jurisdiction, accept that ruling professionally. And third part is promote the legal process, not circumvent it. How she should do it? Example is that ethical legal professional aim to win through fact and law. Aim to win through fact and law, not by manipulating the playing field. Again, just I repeat all these in respect for legal system, uphold fairness and justice, respect court decision, and promote the legal process, not circumvent it. So, in this section, the tip to the paralegal: as a paralegal, understanding these ethical boundaries is crucial. As a paralegal, your work is researching, drafting, and filing documents reflect directly on your legal team. Make sure every action supports justice, not just a strategy. In conclusion, the last section of my breakdown is the conclusion and navigating the complexities of the venue shopping and the recap the key points. Just I'll quick recap the key point to remember. First thing is understand the jurisdiction, know the court power over people and the subject matter. Example is that do not file contract dispute in family court. Match the case with the right venue. Number two, evaluate convenience. Consider how easy it is for witness, client, and evidence to reach court. So, for convenience, example is filing in a city far from all parties might be legal but impracticable. Impractical. Third part is spot biases. If there is a biases, check for the judicial history, local attitude, and community sentiment. Example, don't underestimate how the judge previous ruling can affect your case. And fourth part is use smart strategies. How should you do that? Frame your case and pleading to support jurisdiction ethically. Example for this smart strategies: Highlight events that occurred in the desired jurisdiction without stretching the truth. Highlight the event that occurred in the desired jurisdiction without stretching the truth. And last part of this thing is always act ethically, be transparent, fair, respectful of the legal system. Again, transparent, fair, respectful of the legal system. I'll give you example. A wide forum shopping and misleading tactics and could damage your credibility. Final advice and for venue shopping, elevate your skills and start practicing venue analysis now. Review the case law in different jurisdictions. Learn how judge rules and stay current with the court procedure. Tools. Use tools like Canly, Westlaw, LexisNexis to research venues and build smarter strategies. So, as a new paralegal, mastering this skill not only makes you valuable to your legal system and legal team, it sets you apart as a strategic thinker, not just a rule follower. Be a strategic thinker. Stay blessed. Thank you.